India is currently in the midst of a national debate regarding a new, comprehensive piece of data protection legislation. Whilst India recognizes the right to freedom of expression, as well as a right to life and personal liberty under its constitution, the debate for a general data protection law gained momentum following a judgment from the Supreme Court of India in the Puttaswamy case, which further reinforced that the right to privacy is an inherent constitutional right and highlighted that any legislation that could impact on the right to privacy would be subject to constitutional scrutiny. Following discussion in several committees and public consultations, the draft Data Protection Bill 2019 was introduced in December 2019 to the Lok Sabha and provides further requirements in comparison to those outlined in the previously issued 2018 bill. In order for the bill to pass, it must first undergo 3 readings in each House of Parliament, known as the Council of States, Rajya Sabha, and the House of the People, Lok Sabha. A joint select committee is currently reviewing the bill and is expected to report back to the Lok Sabha before the end of the 2020 budget session in March 2020. The bill seeks to apply to the processing of personal data collected within the territory of India, as well as the processing of personal data by the state, any Indian company, any citizen of India, or any persons or body of persons incorporated or created under Indian law. Provisions which many stakeholders have been paying close attention to have been in relation to data localization requirements. While Section 40 of the previous 2018 bill required data controllers to store a copy of all personal data on a server or data center located in India, Section 33 of the 2019 bill limits this requirement to sensitive personal data. Moreover, Section 34 of the 2019 bill introduces a mandatory requirement to obtain consent from the data subject for cross-border transfer of sensitive personal data, which was not present in the 2018 bill. If introduced, the bill would include both criminal and financial sanctions. Aside from the draft data protection bill, financial services organizations should also be aware of directions to banks to preserve the confidentiality and availability of personal data and sensitive information through systems and processes issued by the Reserve Bank of India. In particular, directions and guidance have been issued in relation to data localization and know your customer requirements. Telecom service providers must also take necessary steps to safeguard the privacy and confidentiality of the information that they receive. This is highlighted under the Unified License Agreements issued by the Department of Telecommunications. In addition, there are penalties under the Unified License Agreements for any data security breaches. The Ministry of Health and Family Welfare also recently published a final report on the National Digital Health Blueprint in November 2019, which provides guidance for stakeholders on adopting digital health measures, as well as in relation to the National Health Policy 2017. The blueprint also highlights the importance of privacy by design and provides guidance on data access management and explicit consent, among other things. To continue researching key compliance requirements in India, use jurisdiction dashboards to quickly access the latest regulatory developments and best practice from leading experts.